We're here in State of Florida versus Winchester, 2016-2265. We're here on the defendant's motion in limine, and I guess it's related. Motion to set bond. I guess it's related because we offered to have the bond hearing previously, and apparently defense declined until the motion in limine could be heard. So anyway, it's your motion. Who's going to be arguing this?
I will, Your Honor.
All right.
Judge, briefly, we did file a motion for continuance on just the motion in limine due to Dr. Manookin's unavailability. If the court is inclined to allow us to go ahead.
Well, I wasn't even aware of it, Mr. Rogers, but you need to make sure if you do something like that last minute, you send it to my office. I've been through my box and there's nothing in my office on this. Just filing it with the clerk doesn't get it to me.
Yes, Judge.
I don't keep track of whatever everything that gets filed with the clerk. What's the problem? You need to be in front of the microphone, please. I see your motion now. Let me read your motion. So when did you become aware of this, Mr. Rogers? You can have a seat, Mr. Commissar.
I became aware of his trip essentially when I inherited the case, which was 2 to 3 weeks ago. We tried to work anything out, became apparent that he would not be able to be here at that time. So I filed a continuance.
Well, when did you find out he couldn't be here?
Judge, I don't have the exact date. I would submit to the court that I believe I inherited this case approximately 2 to 3 weeks ago from Ms. Holmes. And became aware of that problem. I attempted to contact Mr. Jansen. I spoke with him in court. He was informed that they would object to anything, even moving it one day until tomorrow, where he would be back in Tallahassee. We do have sworn affidavits and a transcript from his prior statement, which I believe would be on your honor would need to rule on the motion. If you'd like to go forward in that aspect, the state prepared for that.
Mr. Commissar.
It's correct that we object, and I think it's also correct that all the information, I would proffer everything that Dr. Manookin would provide to the court can be found. There's a 36-page transcript of an audio recorded interview that he gave to law enforcement. That's as you see, the citations in our motion were to that audio recorded interview. It looks like the state met with Mr. Manookin again, or Dr. Manookin, on December 20th. And while his initial statement was not sworn, they got an affidavit from him stating that it is a sworn statement, so we can rely on that. And the state intended to introduce the 13-page law enforcement police report as part of the bond hearing. That's the only other document we would be relying on. So we're fine going forward based on the affidavits. I would proffer that Dr. Manookin live would not provide any testimony that's not provided in the affidavits.
Does the state intend to call Dr. Manookin live?
The state is prepared to go forward with just that affidavit.
If we had a hearing another day, does the state intend to call him?
Yes, Judge. Typically, when we would be hearing these motions and limines, I would put live testimony on for that due to the objection for the privilege. But I don't believe that it is necessary in this case.
I don't know why that was a complicated question. Does the state believe that it would assist the court to hear from Dr. Manookin live in making a resolution of this matter?
No, Judge.
You do not want him here?
I do not.
Well, why are you moving to continue?
I believe that I was under the impression that the court would require live testimony to rule on the privilege.
So you don't think it's necessary, but you thought that I had indicated it was necessary?
I presume that the court would want live testimony to make a ruling on the privilege. I believe that if the court is fine substituting in his sworn statements, that is sufficient to make a ruling. That will give the court all the information that is needed to make a ruling.
So are you making a motion to continue or not?
Judge, the purpose of my motion to continue was I didn't want to be pulled out on an issue because I wasn't able to proffer live testimony on it. And when I became aware that I was not going to be able to do that, I filed a motion for that.
It's a little impossible for me to tell whether we need live testimony or not, frankly. And I'm a little confused as to whether you feel like a continuance would be appropriate or not. I guess you're kind of saying it's up to me whether I want to hear live testimony. Is that what you're trying to say?
Yes, Judge.
Was he available any other time this week other than today?
He's coming back tomorrow. Or he's in the process of driving from Colorado to Tallahassee today. And my understanding is that he would be available at earliest tomorrow.
And how central is this statement to the state's case?
It's a very important.
Well, I think I'd prefer to have live testimony then. I'm going to grant the motion to continue. I can do it tomorrow afternoon at 3. I know we just canceled a hearing Thursday morning at 9 o'clock that y'all were involved in, so we can do it either tomorrow at 3 or Thursday at 9. Either of those times available to the court. You make yourself available either of those times, Mr. Rogers?
Yes, I can.
What, leave to the defense? Pick one of those.
To look at our calendars, Your Honor.
Okay.
Tomorrow at 3 o'clock is fine with the defense.
Okay. Because I know you had that Harvey case set Thursday morning, and we canceled that hearing, so I assume that's available also. What do you prefer?
I think tomorrow at 3, I believe Thursday morning's already gotten filled with something else since you've granted the order.
Okay. All right. So tomorrow at 3 o'clock, and you have your witness present, Mr. Rogers?
Yes, Judge.
All right. We'll take it up then. I wasn't here. Judge Parsons was here. He indicated that the defense did not want to get into the bond hearing until we'd had a ruling on the motion in limine. Is that my understanding?
Yes, Your Honor, if we can address it all tomorrow.
We'll take them both up tomorrow at 3 o'clock. All right?
Thank you, Your Honor.
We'll be in recess.
Thank you, Judge.
You're here on the defendant's motion in limine. After court yesterday, I met with the attorneys and I obtained the statements that they had referred to during the course of the discussion yesterday afternoon. So probably a good thing now I've had the opportunity to review the various affidavits that the parties were discussing. The investigative report, the sworn statements that were given to me, as well as the statement of the witness that we had the concern with, Dr. Manookin. So I've reviewed all those items, so we're probably farther ahead anyway, given our little bit of delay yesterday. I now have a better sense of why y'all felt like we probably did not need live testimony now that I've seen what you had presented. But anyway, we're here on defense motion. You can be heard, Mr. Commissar.
We would invoke the rule of sequestration, and at this point we would rest based on the affidavits that have been submitted.
Do that one more time.
We'd invoke the rule of sequestration if the state's going to call any witnesses, but we don't intend to call any witnesses. We'd rest on what the court has reviewed and we have submitted.
Right. I think I think I've mentioned it briefly, but we probably ought to make a record what it is we're relying upon. I know y'all kind of went through them and gave me what you thought was appropriate. Let's be clear on what everybody believes we're relying on for record purposes. And we need to make these part of the record. I guess the major thing I had was a recorded interview of Dr. Manookin that was transcribed from August 19th. I assume that's 2016. So I think we need to make that part of the record. It's been marked by the state as State's Exhibit 1C. We're in agreement that be made part of the record.
The defense stipulates.
All right, so we'll admit that as 1C. Marked as 1A was the Leon County Sheriff's Office General Offense Incident Report. It's a 11-page document that is a summary, I take it, of the investigation. We agree that be made part of the record.
The defense has no objection.
Yes,
Right.
Judge.
We'll make that part of the record as State's Exhibit 1A. 1B was a sworn statement by Denise Winchester, just indicating that what she'd said before in the recorded statement was true. I don't believe I was given a recorded interview by Ms. Winchester, but do we want to make that part of the record?
Yes, Judge.
1B. All right, 1B will be made part of the record. 1D is a affidavit by Dr. Manookin, just says that the interview he gave on August 19th was a true statement of this affidavit. Is there an objection to that?
None.
1D will be admitted, and 1E is a statement further by Dr. Manookin dated December 20th, 2016, indicating what his professional relationship was with Mr. Winchester. Is there objection to that?
None for the defense.
1E will be admitted. I think I was also given some other documents, but 5 and 6, but they appear to me to be more related to the bond hearing issue. I don't know whether the state thought those were relevant to the motion in limine.
No, Judge. 5 and 6 are relevant, not only to the author.
Right. Okay. So those are the items that have, and the defense would rely on those items for their argument.
We make an argument, but as far as evidence, those items are all we're seeking.
All right. State.
State College, Dr. Stephen Manookin.
Okay. Are you going to have multiple witnesses or not?
Not for the
Motion in limine. All right. So there's no reason to invoke the rule of
I do have another
sequester.
witness for the author hearing in the courtroom.
Well, that's a separate matter. All right. You can call your witness.
State calls Dr. Stephen Manookin.
If you'd face the clerk and be sworn, please, sir.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
If you'd have a seat, slide up the microphone, please, sir.
Dr. Manookin, can you please state and spell your name for the record?
It's Stephen Manookin, Stephen. Manookin, M as in Mary, N as in Nancy, Ookin.
Doctor, how are you currently employed?
I'm an anesthesiologist here in Tallahassee.
How long have you been an anesthesiologist?
I've been, I graduated medical school in 97, and I finished my residency in 2001 and my fellowship in 2002, and then I came here in 2002 and have been here ever since.
Has your entire career been centered around anesthesiology?
Yes.
Have you practiced in other areas?
No.
Have you ever practiced in psychology or psychiatry?
No.
Have you ever made diagnoses with regard to mental health disorders
No.
or substance abuse treatment?
No.
Have you ever in any capacity treated Brian Winchester?
No.
Do you know Brian Winchester?
Yes.
How do you know Brian Winchester?
We're friends.
Okay. How long have you been friends?
I think I met him about 2004, 2005.
Okay. Do you know him from the support group?
I know him from water skiing in a support group, yes.
Okay. And you already testified you've never seen him in any sort of official capacity,
No.
meaning you've never treated him?
No.
Okay. I want to talk about the events that brought you here today. We don't necessarily have to go into the statement. I believe that the judge has that information in front
Okay.
of him. How did you come to meet up with Mr. Winchester on the day in question?
Well, he and I are friends, and I'm his sponsor in a sex addict and sex addiction. And he and I talked all the time, and we had lunch a lot, and he called me on that day. I guess it was a Friday, and I was getting out early at work, and he said, I want to have lunch. I've hit a new low. And I said, well, what happened? Oh, I'll tell you when I get there. And I'm like, okay. So I got there at Village Pizza, and we were sitting outside.
About what time did you get to Village Pizza?
It was probably around noon or so.
So around the lunch hour?
Yes.
Can you tell me, was it busy?
It was pretty busy. I mean, there were people around.
Okay. There was waiters and waitresses.
Yes.
And other customers.
Yes. I mean, we were sitting right outside on the, walkway there.
Were there other customers?
On the sidewalk.
Were there other customers on the sidewalk?
Yes, there were people walking back and forth.
And were there people walking into the entrance?
I think so.
Would you describe it as a private setting?
Not really.
Okay. And from there, what happened next?
Well, he looked at me, and I'm like, what's going on here? And he's like, this is in confidence. And I said, okay. I was thinking he was going to tell me he'd had some sort of sexual encounter that, they got him to a new low. So I was waiting for him to tell me about the sexual thing he did. But instead, he told me that he went into his wife's car and hid in the back seat of her car. And then when she got in, he pulled a gun out on her and forced her to drive around and talk to him.
Did you clarify if the gun was just on his person, or was it actually...
I asked him, did you just have the gun on you, or did you point it at her? And he said, I pointed it at her. I said, okay.
Cool. Were you concerned for your friend?
Very.
Okay. Why is that?
Well, I like him. I mean, he's a friend of mine. When I first encountered this, I thought, oh, geez, this is just a new low for him. I didn't think I didn't really think of the criminal implications of what was going on. I was just thinking about him, and I was like, wow, you got to get yourself help, you know. And I thought he was suicidal at the time, although I'm not that kind of doctor. And
Why did you think he was suicidal?
well, he was just really upset, and he was acting extremely paranoid. I mean, it was the day that Biden was coming in town, and there were police everywhere. And I didn't know Biden was coming in town, and I guess he didn't either. And he was looking at a helicopter flying by, thinking that it was they were after him. And I'm like, I don't think they're after you, but something is weird going on. And he's always a pretty stressed out individual, but he was a lot more stressed out than normal. I mean, I think he probably realized, oh God, what did I just do?
So you've been friends with him for a number of years.
Yes.
Over a decade.
Well, I've only been friendly with him for probably 4 or 5 years.
So you've seen him on good times and bad times.
Right.
Did you have him try to get in touch with his therapist?
Yes. I tried to get him to go into like a behavioral health unit or something, and we went into my car and we called he called 2 different places. Of course, neither one answered. So I told him to call his therapist and maybe make an appointment with him. So he called his therapist, made an appointment for 5 o'clock that evening. And then I'm like, well, maybe I should like take you somewhere to the behavioral health unit, you know, because I was really worried about him. And he goes, no, I'm going to go visit my dad. I'll be okay with my dad. And I said, okay. And that was it. And then on the way, and then I was supposed to meet my therapist for just coffee at noon or at 2 that day. And I was running late because of the traffic with Biden, and they shut down like all of Thomasville Road, and I couldn't get across Thomasville Road, which is why I remember the times. And then at 2 o'clock, Brian called and said, you know, I'm in real trouble. We didn't have this conversation, and that was it.
I want to go back. You said you met at Village Pizza around noontime.
Mm-hmm.
How long were you outside?
I don't know, half an hour or so.
I'll pass the witness.
Cross.
How long were you the defendant's sponsor?
Why don't you go to the podium, please, Mr. Commissar, help the court reporters.
How long were you the defendant's sponsor in the support group?
Well, I guess he probably came in 2012 or 13. I'm not sure. But since then,
So at least 3 years?
I would say so.
And that relationship included him speaking to you about his mental and emotional conditions at different times?
Yes.
In medical school, you did learn some psychology.
I mean, I guess.
You studied it.
I did read books on it, yes.
And you have the ability to Baker Act someone, correct?
I don't think I do, no.
Are you licensed to practice medicine in the state of Florida?
Yes.
During part of your relationship with the defendant, you discussed him needing to take antidepressants and what different antidepressants he could take, correct?
Yes.
The therapist that you met with after you met with the defendant that day, is he named Ron?
Yes.
What's his full name?
Ron Rickner.
And he's a therapist that both you and the defendant share?
Correct.
And you met with him at a Starbucks?
Well, I was going to meet with him at Starbucks, but I went to his office instead because we couldn't get to Starbucks because of the traffic.
And when you and your therapist sit at a Starbucks and discuss things, you discuss them in a way so people don't overhear them, correct?
Correct.
Okay. And you think you have your therapist's confidence and that it's privilege when you discuss things with your therapist at a Starbucks, correct?
True.
Much the same way the defendant was not shouting these things but speaking with you at Village Pizza in confidence?
Probably.
Okay. It was about noon that you met that day?
Right.
One of the things that's been placed into evidence today is a police report. And the police report alleges that the defendant left a voicemail for Denise Winchester at 11:45 on the date you had lunch. And the police allege that the transcript of that voicemail is, hey, I just wanted to call and tell you that I went by Ron's, but he's not there, so I'm meeting Steve. Given the time of the voicemail, the Steve he's talking about is you.
Correct.
And the Ron he's talking about is the
Correct.
therapist that you share? Okay. So prior to reaching out to meet with you for lunch, he attempted and actually went to the office of his therapist per that voicemail?
You'd have to ask him.
Okay. But the Ron he's discussing is the therapist?
Right.
During your conversations with the defendant at Village Pizza, did he state that he had tried to reach out to the therapist that you share?
I don't remember.
And he used the words both privileged and confidential before having his conversation with you, and you confirmed to him that the conversation was both?
I said okay, thinking that he was going to tell me that he had sex with a crazy sexual experience. I was not aware that he was going to tell me that he committed a violent crime.
He used the word both privileged and confidential with you prior to making
Yes.
the disclosure, and you confirmed to him that it was
Sure.
both privileged and confidential? After speaking with him, you went to your car and you felt that he needed to go to the hospital and get treatment, and that you were looking at things from a psychological perspective?
Yes.
And he had made statements to you that he had been suicidal the night before, but you felt that he was suicidal that day.
Yes.
At that point is when you called 2 hospitals and neither answered,
Right.
and then you called the therapist to make the appointment for him for later that day.
Well, he called the therapist, not me.
Was there anything different about the phone call that he made to you that day prior to lunch than a normal, hey, let's go have lunch phone call?
Well, by the tone of his voice, I could tell something wasn't normal with him. I mean, he said I hit a new low.
And you asked him what it was, and he told you he wanted to talk to you about
He said,
that
I
person.
won't talk, let's talk in person.
Okay. And at that point, you had already eaten lunch that day, but based
Right.
on the distress that you could tell was coming from him, you still agreed to meet with him.
Right.
And you didn't actually eat any food at Village Pizza,
I had a Coke, Diet Coke.
but the defendant ate lunch.
Yes.
Did he at any point talk in a way where you felt he was doing something so other people around would hear what he was trying to share
No.
with you? During his conversation with you, were there times when he stressed that the firearm was not intended to hurt Denise Winchester, that it was intended for himself?
He did not, I said, I was worried he was going to shoot her, and he said, no. But he never said it was for himself, I don't think.
When the defendant started to disclose to you what he disclosed, is the perspective you took, I need to find out if he's suicidal or I need to find out if he's okay?
Well, the perspective, I was shocked when he told me. I didn't have any perspective. I was like totally shocked. I thought, again, I thought he was going to tell me he had, a strange sexual experience. And when he told me that, I didn't know, I really was shocked. I didn't really look at it from any point of view. I was just kind of sitting there looking at him like, what the heck is going on here? And then over time I processed it, but by then he was gone. I did think he was extremely paranoid that day, but I didn't really think a whole lot right the very minute that it happened.
If what the defendant had disclosed to you was some sexual conquest, would you have kept that confidential as part of your support group?
Yes.
was what led the defendant into describing to you what had occurred earlier that day, your question to him, why are you suffering from a new low? You needed to know, he used the term new low, correct?
Right.
And you needed to know why he was suffering from
Right.
a low. And as a result, he told you about the incident of earlier that day.
Correct.
Nothing further.
Redirect.
Nothing, Judge.
All right, you can step down.
Thank you.
Do we need to keep him any further?
No, Judge.
None from the defense.
You're free to go about your business or sit in the courtroom as you see fit. Further testimony, Mr. Rogers?
No, Judge.
Any other evidence that you wish to present?
Not for this portion of the hearing.
Okay. I just wanted to know. I knew there was a gap in the numbers, and I assume those other matters are for the bond hearing.
That's correct, Judge.
Okay. All right. Make argument, Mr. Commissar.
Most of what we're relying on is basically what's laid out in our motion, Your Honor. We point out that the psychotherapist privilege in Florida is very unique in that it did not exist in common law. It was created purely by the legislature. Another element that makes it unique is that because it's legislative created, it only has statutory exceptions and it's not subject to any balancing or needs test. Another unique fact is that the statute gives a very broad definition of both the terms psychotherapist and a very broad definition of patient. It considers patient someone who consults for an emotional condition, and it considers a psychotherapist anyone who's licensed to practice medicine who is consulting with somebody about their emotional condition. One thing that we laid out in the motion that we felt was important to stress is that there are not many cases that cite to this privilege, but one of them talks about what the legislative intent was in creating it. We noted that at number 19, and it comes from the DK versus Parents of DK case at 780 Southern 2nd 301. It says that the intent of the statute governing the psychotherapist patient privilege is to provide confidential communications and to encourage patients to seek treatment for mental and emotional conditions. And then there's a later quote that says, thus, in order to encourage patients to seek treatment for mental and emotional conditions, the statute provided confidentiality of those communications. What the legislature has done here is they've said that no matter what, we do not want suicidal people walking around without anyone to speak to. And the fact pattern we have in this case is an individual who was suicidal the night before, allegedly suicidal that day, who had a therapist and stopped, actually physically, or according to the voicemail, attempted to get treatment from that individual. That individual is not available, so they reached out to their sponsor from a support group that is a confidential group, and their sponsor also happens to be a medical doctor. It's a medical doctor who's discussed the defendant's depression with him in the past and discussed whether he needs to be taking antidepressants in the past. When he reaches out to this individual, he doesn't ask them to go have lunch and then mention what he mentioned as an aside. He said he hit a new low, didn't want to talk about it on the phone, and they needed to speak in person. At that point, you've heard, and you see in the transcript of Dr. Manookin's testimony, that he was looking at it from a psychological perspective, that he told the defendant he had to get treatment, that he called 2 hospitals and they didn't answer, that he then made an appointment with the therapist that they do share. You'll see in the transcript that he considered wanting to take the defendant to the hospital right then and there because he thought he was suicidal. And he does tell law enforcement in his interview that this was different than a normal phone call due to him hitting a new low and having to talk. Our position is that this is an individual who did everything right, that the legislature intends this communication to be privileged, that when an individual is going through an emotional or mental health crisis, it's a very slippery slope for them to seek out a doctor after seeking out their own doctor, who's also the sponsor in their support group, who also has confidentiality with them, who's provided them medical advice in the past, and then for the state to argue that that person doesn't qualify and under a very, very broad legislative privilege. There's not many cases on this. There's one case that brushes on the same facts we have here. It's the Tops case, State v. Tops, 142 Southern 3rd, 978. It was provided attached to the motion. This is from the 4th DCA in 2014. What they were addressing, which was the issue of first impression at the time, was a case where a law enforcement officer had someone in custody, so he was present and overheard what was said, and whether that waived the privilege. They held it wasn't. But what's important about this case is that the DCA didn't need to discuss whether the court was right or wrong in suppressing the statement. They, based on reading it, I almost believe the state may have conceded that it was a privileged communication, and they only argued that the privilege was waived based on the officer being present. The facts of that case was an individual who was charged for stabbing a dog to death and attempted to admit himself into the hospital. When law enforcement arrived at the hospital to arrest him, he was being seen by an emergency room doctor, not a therapist, an emergency room doctor. And that doctor was trying to figure out, is this person cleared to go to the jail, or are they suicidal and do they need to be brought into inpatient commitment? During that time, the court stated that a customary part of an evaluation requires the physician to ask the patient what brought them to the hospital, much like Dr. Manookin needed to know why was the defendant at a new low. And in the Tops case, the defendant responded by telling the ER doctor that he had stabbed a dog. And the court ruled that that statement that he had stabbed a dog was privileged because he was describing to somebody who was licensed to practice medicine and who was caring for an emotional condition the person had at a time, why the person had been brought to the hospital. So our position is that the things that the defendant shared with Dr. Manookin to describe why he hit a new low were being shared with someone that the defendant had sought out because he knew the individual was privileged. He confirmed it was privileged. He knew he was a medical doctor. He was not able to get help through the normal channels, and at all times we believed it was a privileged communication that shouldn't be allowed to be admitted against him in court, and we think that that's exactly what the legislature meant when they created the statute.
Mr. Rogers.
What I see here is a statement to a friend who just happened to be a doctor. Dr. Manookin was not engaged in diagnosis or treatment. He was a friend who thought his friend needed help and attempted to have a friend call his therapist who could provide that level of professional help, and also to have his friend call behavioral health units so that they could try to help him further. Dr. Manookin's not trained in psychotherapy and was not acting as a psychotherapist, therefore the privilege doesn't apply. Furthermore, the communication was on a sidewalk patio at Lowe's Pizza at noontime. So even if Dr. Manookin was acting as a psychotherapist, that communication is not confidential. It's not reasonable to believe that waiters, waitresses, patrons, anybody else walking by would be privy to at least some details or aspects of that conversation, no matter how hard you tried to hide it or how much you tried not to talk about it when people were around. What you have here, Judge, is a longtime friend who's never treated the defendant in any capacity, he's never diagnosed or treated any mental health disorders. He took the steps to have the defendant call his therapist. Defendant called both behavioral health units. The defense's argument essentially would serve to make any communication to Dr. Manookin by anybody a psychotherapist-patient relationship, and that's not what the legislature intended. And I think the packet that the defense provided you is actually very telling if you look at the situations that's cited in these cases. If we talk about DK v. Parents, which is 780 Southern 2nd 301, this was in the setting of trying to get in testimony from a child psychologist. And State v. Pamela Getty 817 Southern 2nd 901. This was again was the victim's psychiatrist. Also provided to the defense is Guerrier v. State 811 Southern 2nd 852, where this was a jail psychiatrist having conversations with the defendant. And then the Tops case, as the defense talked about in detail, was an emergency room doctor in a hospital setting determining an evaluation for purposes of the Baker Act. All of those are very different than meeting Village Pizza for being there for your friend who's having a hard time. Now, it also gives you the court Elias v. State. For the record, it's 593 Southern 2nd, 260. May I approach you?
You know.
Essentially, Judge, if you look at Head Note 2, this is a physician who treated a prosecution witness for purely physical problems. It was a heart condition. Was not a psychotherapist within the meaning of the psychotherapist patient privilege. That physician never diagnosed or treated the witness in a mental or emotional capacity. In fact, the prosecution in that case actually argued that the privilege applied because the doctor had treated the patient for anxiety in the past. The footnote shows that was actually by prescribing a stress-related drug, Ativan, that he renewed a prescription for, which may well be for the heart condition that was being treated in the first place. But the court in that case found, Judge, that this, when treated just purely for a physical deal, we're not talking about a psychotherapist-patient relationship. Therefore, for all those reasons, I think the court should deny Vincent's motion and allow this testimony to come into trial.
Further, Mr. Commissar.
Our response would be twofold. The first would be that we believe the court has to limit itself to the definition of psychotherapist that's given in this statutorily created exception. They didn't cite to another, there's other definitions in the law, and for the purpose of this privilege, they actually created their own definition, and it's extremely broad. And it probably doesn't cover for insurance billing purposes or for medical malpractice. But what they describe here is that a psychotherapist is a person authorized to practice medicine in any state or nation, or reasonably believed by the patient to be so, who is engaged in the diagnosis or treatment of a mental or emotional condition, including alcoholism or drug addiction. And what we have here is diagnosis or treatment of a mental or emotional condition. Dr. Manookin may have not wanted the patient that day, but when he agrees to meet with someone who is suicidal and tells them it's privileged and confidential, and the person shares with them the issues that are going on and their mental and emotional condition, they do qualify under the 90.05 sub 1 sub A sub 1 psychotherapist. So in the same way that if I was to have a heart attack right now and a doctor was in the audience and they treated me, I wouldn't be their patient, but they would be treating my then physical condition. This was a suicidal man who showed up to a doctor, and the doctor treated his then mental condition. And he's admitted he looked at it from a psychological perspective, and he diagnosed the man as suicidal and thought that he needed more help. He could have talked him down and maybe not diagnosed him as suicidal and told him that he was free to go about his way. As far as the state citation to Eris, what they read to the court makes clear that this case doesn't have really any bearing on what we're dealing with here today, because this was a situation where they were treated for purely physical problems. If Dr. Ron Richter, the therapist both patients share, treated the defendant for a broken arm, that interaction wouldn't be privileged. And that's what the Eris case is really dealing with, is there are a lot of states that have a doctor-patient privilege, and the psychotherapist-patient privilege is a smaller subset of that. One of the cases that we cited to in our motion notes that Florida uniquely does not have a doctor-patient privilege because there wasn't one in common law and our legislature didn't create one. So in this case, we're dealing with the only privilege that exists in Florida is the definition of psychotherapist that's provided, and we believe that that extends to a medical doctor who's treating a then mental or emotional condition, which is clearly what occurred in this case. The only other argument the state made was that they were in a public place. You've heard from Dr. Manookin that the defendant didn't do anything that would have caused the conversation to be overheard. Additionally, you heard that he meets with his own psychotherapist in a Starbucks and believes that those conversations are confidential. And when you look at the Topps case again, they kind of touched on that issue. And they said on page 2 that the issue is that it's when the statement is not intended to be disclosed to anyone beyond the doctor or deputy whose presence facilitated the examination. So it's clear that the statements that were made to Dr. Manookin in this case were not intended by the patient to be expressed to anyone beyond that. And that's made most clear by him confirming that it was both privileged and confidential before making any disclosures.
I'm going to deny the motion in limine. First, I don't find that Dr. Manookin was operating as a psychotherapist. He was a friend trying to help the defendant. He was not trained to be a psychotherapist. He does not meet the definition of 90.503 sub 1 sub A number 1 because he is not engaged in the diagnosis or treatment of a mental or emotional condition. I think his testimony was crystal clear on that. Assuming for sake of argument that he was acting as a psychotherapist, I find the dangerous patient exception as set out in Guerriere versus State would apply. Guerriere seems to be the closest to the situation we have, although in that instance it was very clearly a psychotherapist. So for that alternative basis, I would deny the motion. I don't find that TOPS is applicable here. TOPS is dealing with whether there was a waiver. I will specifically say I do not find a waiver in this case. I don't find a waiver by the location as argued by the state, although I do find that the setting supports my finding that Dr. Manookin was not operating as a psychotherapist as they meet at the pizza place. So deny the motion in limine. Y'all ready to move on to the motion Arthur hearing?
Yes, Judge.
Yes, Judge.
All right.
Marcus Winchester. Your Honor, I want to read a letter from Brian's son. To the Honorable Judge Jane Plankinson. I cannot begin to understand the difficulty of deciding the sentence of anyone. However, I would like to say a few words about my father, Brian Winchester, in complete honesty, no matter how hard or difficult that it is to write, in hopes that they will help you with your decision. I know that the minimum sentence is 10 years, including time served, which means I will be almost 30 before my father is let out of prison. I do not know that there has been a request. I also know that there's been a request for the maximum sentence, which I find an unfair sentence for someone who made this mistake. My father is only a man, and what man can say he's never made a mistake in his life. He was locked up while his wife left him. His mother, my gram, lost her battle with cancer, and I moved away against his will. My point is, excuse me. My point is, he has suffered many tragedies along with being in jail. It is my belief that my father should not be given the maximum sentence because that is not what he's earned. My father has never physically harmed me in any way, and to my knowledge, anyone else. What I want for my father is help, which I know he so desperately needs. Prison, in my opinion, is not what he needs. Rather, mental counseling and psychological help. But I know that prison is an inescapable future for him. Therefore, I request that the mandatory 10 years with time already served be given to him, and I hope that my words will help you to see that he is not, in fact, a danger to society, but rather a troubled man who's lost his way. I'm very sad to see him in the situation he is in now, and I humbly ask for mercy for him, as he has already suffered so much where he is. Respectfully, Stafford Winchester. This is my statement, Judge. Thank you, Your Honor, for allowing me the time to speak to you today. I'm Marcus Winchester, father to Brian Winchester. He is my only son, along with my daughter, Jennifer. I've owned an insurance and investment agency in Tallahassee for nearly 45 years. And Brian has worked with me over 25 years as a financial planner. My life, my daughter's life, and my grandson's life with Brian's life will never be the same. I know the charge against him carries a 10-year mandatory sentence, and you have no options to lessen it. It would break my heart if additional time is added to those 10 years. My family's life, as I knew it, is over. My 253 visits to Brian in jail left a little piece of me each time. Especially as I had to share with him the daily details of his mother, Patricia, my wife of 48 years. Her 15-month battle with aggressive stomach cancer, a battle that she lost last month, November the 5th. Brian had a special bond with his mom. She was diagnosed 1 month before he was arrested, and I believe it was a contributing factor in his state of depression, along with estrangement with his son and a failed marriage that pushed him to the brink of suicide in his careless behavior. I am grateful to Denise for talking him into calling me that day, which they did. I so wish I had been able to answer that call instead of it going to voicemail. No person should be defined by the actions of a single stupid event, yet we are. I'm 68 years old and will be 77 at the end of Brian's mandatory sentence. Brian's mom passed away with hope in her heart that one day soon he would be free again. He lost her, his career, his income, his home. And as a father and a grandfather, I respectfully ask that Brian and I have some years of freedom together outside of prison, and you would grant him grace and leniency, letting him return as soon as possible to the family and friends that love and support him, as evidenced by those present today. I dearly love my son and pray for your grace and mercy toward him. Thank you.
Thanks, sir.
My client would like to address the court. Sir.
Good afternoon, Your Honor. As you know, I've previously written you a letter expressing my remorse about what happened. I fully accept responsibility for my actions, and I know that I deserve punishment. I apologize to everyone I've disappointed.
Father, I respectfully ask that Brian and I have some years of freedom together outside of prison, and you would grant him grace and leniency, letting him return as soon as possible to the family and friends that love and support him as evidenced by those present today. I dearly love my son and pray for your grace and mercy toward him. Thank you.
Thanks, sir.
My client would like to address the court.
Sir.
Good afternoon, Your Honor. As you know, I've previously written you a letter expressing my remorse about what happened. I fully accept responsibility for my actions, and I know that I deserve punishment. I apologize to everyone I've disappointed, to my family, to my friends, and especially to Denise. I admit my wrongdoings on that day, but I don't agree with the recent characterizations by Denise of our marriage and relationship. While our relationship was unhealthy in many ways, it was a mutual, consensual, and ongoing relationship that continued even after she first filed for divorce in August of 2015. As you've heard, many things contributed to my state of mind, which led to what happened on August 5th, 2016. My mom was dying of cancer. My marriage had failed. I felt financially ruined. But when I lost my son, that was the nail in my coffin. I lost all hope when I lost him. I wanted to end my life that day. In Denise's words to investigators, quote, "He was very suicidal. All he wanted to do was talk to me. I don't believe he was there to hurt me. He was weeping and apologizing. I wanted to follow through with what I said. I wanted to talk with Brian's dad," end quote. Never, ever did I have any intentions of harming Denise, nor would I. Nonetheless, I do know that she was hurt by my actions, and again, I am truly sorry. Your Honor, I recognize that my sentence is completely in your hands. I hope that a decade in prison is sufficient punishment in your judgment. I don't want the rest of my life to be defined by my actions that day. I ask that you give me a chance to rebuild my life and my relationships with my family and my son. Thank you, Your Honor.
Thanks, sir.
Probably, yeah.
Mr. Chief.
Your Honor, back on August the 5th of 2016, Denise Winchester, now Miss Denise Williams, awoke to a nightmare. She tried to leave her home just like she normally would. And as she got into her car, a Suburban, with three rows of seating, Mr. Winchester was laying in wait for her. Sometime during that night or early morning hours, he crawled into that truck.
Go ahead. I'm going to take a short break before I sentence, and I'll read over it.
Yes, sir. I kind of figured you would. The side of the state would like to call Miss Denise Williams, please.
You mind? Start by stating your name, please.
Denise Williams.
You wish to make a statement to the court, Ms. Williams?
Yes.
You may.
Your Honor, I'm here today to ask you to sentence Brian Winchester to the maximum penalty under the law for the crimes that he committed against me on August the 5th, 2016. It's been 16 months since he broke into my car, hid in the back waiting on me, scared the life out of me, jumping up while I was driving, shoved a gun in my ribs, and kidnapped me. I have relived it every single day, and it is always with me. He made the choice to plan and act out the crimes of August the 5th. He is the reason he has been sitting in jail the past 16 months. He's the reason that he lost me and his children. Since August the 5th, 2016, I have been diagnosed with post-traumatic stress disorder and with extreme anxiety. I start each day with the memory of him jumping out of the back, and I end each day feeling the gun shoved in my ribs when I turn on my right side trying to sleep. Each day when I get in my car to go to work, I look back to check the back seats. This is my life now. We all have the right to feel secure and safe, and he took my sense of security and safety from me. He stole it from me, and I will never be. What?
I'm sorry. Go ahead.
He stole it from me, and I will never be the same. I live each day with the fear of his retaliation for my decision to tell. He will finish what he has started, no matter what age he is when he's released. For all of these reasons, I'm asking you to sentence him to life in prison for the crimes he has committed. It comes down to my life or his, and I'm asking you, please, to choose life. Thank you.
Thank you.
Your Honor, as Ms. Winchester said, she lives in a constant fear. Many times, in some ways, courts have afforded sympathy sometimes for defendants. I'm asking the court to pay attention to Mrs. Williams' case, or what her statement is.
Good morning, folks. As I understand it, we are here this morning for resentencing in case number 18 CF 1592, State of Florida versus Denise Williams. I did have a preliminary discussion with counsel as to just the logistics of this morning. A couple things I wanted to address before we got started. There was a motion to have me enter the order vacating the conviction and sentence on the charge of first-degree murder. I believe that that is an appropriate thing to do, and I have signed the order, and I'm handing that to the clerk. The other issue that we had is whether or not to reinstate count 3, which is the accessory count. I do not intend to address that this morning. My intent is to proceed with sentencing as to count 1. We will address count 3 at another day, and of course I believe that means that I will not be including that in the score sheet for this sentencing. Also, before we get started, I did want to inform the parties that again, I was not the judge that tried this case, but I have reviewed the court file in this cause and the file and pleadings to date, and all the hearing transcripts and the transcripts of the trial. I've read and reviewed the mandates and opinion of the First District Court of Appeal, And I have reviewed all letters that were submitted on behalf of Ms. Williams, not only those provided to me, but also those that were provided to Judge Hankinson at the time of the original sentencing. I have reviewed the 2019 pre-sentence investigation, and I have, for purposes of today, discounted and not considered anything relating to either count 2 or count 3, which are the murder and accessory charges. I have also reviewed the defense motions and defense sentencing memorandum, and I have also reviewed letters that were provided to me this morning by the State Attorney's Office from the Kirkland family. I don't know if that covers everything I've reviewed, but I wanted to let you know that I think I've complied with the Florida Rules of Criminal Procedure and done an extensive review. So, with that being said, is the state ready to proceed?
It is, Your Honor. Just one clarification as to the count, the accessory after the fact reinstatement. Are you going to permit just arguments put on the record? And I understand you.
No, I'll let you argue. I'm not.
Ruling.
If we need to address that today, as far as argument, I'll let you do it, and then I'll decide. I mean, as I see it, there's already been a verdict on that, the hay's in the barn on it, so to speak, and it's just a matter of is it appropriate to reinstate under the circumstances and in light of the first district's ruling. So we'll go from there. But if I reinstate that, the only downside would be that we would have to come back for a separate sentencing on that.
Yes.
Y'all see it that way?
Yes, sir.
All right, very good. All right, so having asked if the state is ready to proceed, is the defense ready to proceed?
Defense is ready, Your Honor.
Okay. And then has the state prepared a score sheet that would be only asked to count 1 in light of the reverse?
I have, Your Honor.
Reverse, let's count 3. And,
I'm going to go ahead and provide you both simply because of the fact since you're going to be ruling on that later on, but the top one is the one for me.
All right, very good.
And both have been shown to counsel.
And I was going to say, Mr. Padawan, Mr. Way, y'all have both seen this?
Yes, Your Honor, we reviewed,
All right.
no objection as to the guideline range of counsel indicated on the score sheet for today's sentencing.
Okay. So as to, as I understand it, working under the sheet that I'm going to be using for today, the lowest permissible sentence would be 21 months and the highest would be 30 years, correct?
That's correct.
All right. In light of the circumstance, the way I see it, we do have a jury verdict guilty as to count 1. That we have been up to the first district and we've come back, and we are now to the point of doing the sentencing as to count 1. In light of the other things being thrown out and not being considered today, does that change our costs and fees? No, sir. So I would not have to address costs and fees again today. Yeah.
The only thing I could think of, Your Honor, is if there were costs and fees associated with count 2, of course, those would have to be vacated.
Right.
Otherwise,
All right.
I think that's right.
I would agree, but I think the count 2, I think they're going to be the same, if I'm not mistaken.
All right. Ma'am, what are you showing for costs and fees right now? 26.25, and that breaks down as to what?
You have the 5% charge, which is $105, and the court cost is $420.
Okay. And the $2,100 fine is for? All right, y'all agree that's the case?
Yes, Your Honor.
Yes, sir.
Okay, very good. All right. All right, well, that being the case, would I decide wish to be heard further before the imposition of sentence? And the way I intend to do this today is I intend to hear from the defendant first, followed by the state, and then give the defense the last word. All right? Oh, and then before we start, Mr. Potabalo, the other thing, just for the media, there was a request with regard to Ms. Williams' daughter as far as not showing her image or broadcasting her under Marcy's law. It is my request that we respect her privacy if we can do so. And I've talked to the lawyers about that. And the lawyers have any objection?
No, sir.
You don't have any from the state, Your Honor. However, I do believe the media has the right to be heard during that
No,
situation.
I understand that, and,
Yes, sir.
And if anybody wants to raise that, they can do that. But again, my preference is that we proceed ahead right now. Mr. Potabalo?
Thank you, Your Honor. We have 5 witnesses. The first 3 will be Denise's sisters, Darla Casso, Deanna Lamb, and Deborah McCraney. I'd like, if it's okay with you, to call them all up to the podium with the idea that Deanna Lamb will speak for the group.
Very good.
Your Honor, are you going to want them in the middle?
I think that if it's going to be them up together, there's probably more room right there for them to stand together.
Take this on.
For me, it's whatever you're comfortable with. Okay. And I will tell you, I mean, I know that we're trying to wear our masks as best we can. I have taken mine down for right now, and I'll probably pull it up at times. I think it's important, just from a sense of justice, for people to see the face of a judge who's conducting a proceeding. And if you feel it's important for me to see your face now, I'm certainly fine with that. I don't want to preclude that. I will tell you I've had all my shots.
Okay. All right, thank you. All right. Well, good morning, Judge Carroll. My sisters and I thank you for the opportunity to talk to you today. First, we would like to say that our family loved and will always love Mike Williams. He was a member of our family. He was Denise's husband, our niece's father, our brother, and a son to our parents. For my son, Mike was his very best friend. Everyone in this room who knew Mike knows of their bond. Bubbles was the name that my son gave Mike, and Mike is loved and missed by our entire family. We grew up in a loving home. Our parents taught us respect, compassion for others, a strong work ethic, importance of education, and most importantly, faith and love for God. From an early age, Denise had a passion to improve the lives of those she met. She raised her daughter with these same values, just as she and Mike had planned to do. Denise's family, friends, and co-workers know her to be generous, positive, gracious, compassionate, hardworking, and humble. These are character traits that she's been able to rely on and share in her current condition. We love our sister. We believe in our sister. We support our sister, and we are very proud of our sister. We are anxious for Denise to come home where we can assist her with her future plans to improve the lives of the women in the Florida prison system. Many that I like to say that we've had the opportunity to meet, talk to, and we are very passionate about helping these women. We respectfully ask for the minimum sentence of 21 months, and we thank you for your time and your consideration.
Thank you. Thank y'all.
Your Honor, we would next call Carla Daniels, a person who is a longtime friend, colleague, and co-worker.
All right.
Good morning.
Good morning, Ms. Daniels.
Thank you for letting me speak. As I said, my name is Carla Daniels, and I have known Denise Williams since high school. We really didn't become friends until around 1994 when we started working together, and we were work friends for quite a while. And then in 1999, we both had daughters at the same time, so we became closer friends. We were living through, nighttime feedings and all that kind of stuff together. Over the years, we became really close friends. Denise is one of the kindest, most genuine people that I know. She's always willing to help her friends and coworkers. She's the first one to send get well cards or thinking of you cards and creating care packages when people are in the hospital or their family members are in the hospital, or just when they need encouragement. As a manager, she was always making sure that her staff not only were doing their work, but that they were doing okay in their personal lives. If they didn't look like things were going okay, she would sit down and say, "Is everything, how's it going?" She was always trying to help people in any way possible. My children, who are currently now, I have a son who will be 18 next week, and my daughter's 21, they consider Denise their second mom. They knew that if they had a problem or needed help, that without a doubt she would come and take care of it, or be able to, love them unconditionally. Even if they were wrong, she would help them get through it. This has even stayed true while she was in prison. My daughter recently graduated from nursing school, and that's stressful. She would be crying and in tears, and she would send Miss Denise an email, and Denise would be able to calm her down and say, you can do this, you can get through this. And she would even send encouragement through when she talked to her daughter. She would pass it on to, tell Meredith she's doing okay, she can get this done. She, did not, even though she was in a difficult environment, she was still trying to help us out. My son, who was, a young teenager when she went to prison, he asked to go see her, and we went in once, and he had to touch her, hug her, make sure she was okay. But he said, "Mom, I can't go back again." She said, "I can't see her in this place because I just want to take her home." She is a wonderful friend in person. She would have been on the top of my list if something had happened to me and my immediate family. She would have been on the list to take care of my kids and to raise them. In fact, just this last week, we were cleaning out my in-laws' house, and we found a list of people who were allowed to take my kids to the doctor if my husband and I weren't available. I'd forgotten Denise was on the list. She is a good and caring person, and I don't know how else to say it. This clearly demonstrates that, I thought she's a dependable, good, kind, caring person. Over the years, Denise has done all kind of volunteer work she did prison ministries years ago. She's volunteered in orphanages, and she's not the type of person that just goes and does this kind of thing. She makes connections, and she's still in contact with people that she met in these conditions over the years. Even now, when we have something coming up, we ask her to pray for us, and she's very diligent and asks the people on her, the girls on her floor, and they're praying for things happening out in the real world. Denise always talked to Ansley about Mike over the years. Her house had pictures of Mike on the wall. He was not forgotten at all. I worked with her when Mike disappeared, and she was not the same person after that happened. She was just so withdrawn and quiet. In fact, that's when we became the closest friends. I made a point of making her get out of the house, come do stuff, take the girls to the playground, to the beach, just to get her out of the house. And that's when we really became very close friends. Denise has quietly lived her life while she was here in Tallahassee. She was always being scrutinized by the public, by the media, law enforcement, everybody. But she raised her daughter. She raised her to be an independent, kind, loving girl. And Denise just tried to live her life. She would see a lot of ugly things written about her. Kids would say things to Ansley. You would hear all kinds of things. And she didn't run away. She stayed here so that her daughter would be around her aunts and uncles and the family that loved and supported her. She didn't live a lavish lifestyle. She was very careful how she spent money. And the public's perception of Denise was so wrong, it was laughable. What I would read would not be what I saw day in and day out working with her 40 hours a week and how things went along. The media, the state's attorney, their portrayal of Denise was the exact opposite of reality, because I lived that reality with her. All this boils down to the fact that Denise is a good person who loves her daughter, friends, and family. No matter where she is, she strives to help the people around her. This can be demonstrated by how even when she was incarcerated, she had no hope of getting out of prison. She was still helping the ladies that she worked with. She was teaching them the GED. She was excited to be able to help them and to do something for them. So I'm proud to be Denise's friend, and I'll always be a friend, and I think that she needs to get out of prison. It has no help for anybody for her to be there. Thank you.
Mr. Padovano?
Thank you, Your Honor. Now I would like to ask Denise Williams to come up and make a few comments to you about the case.
Very good.
Judge Carroll, thank you for your time today. Thank you for reading the letters from my family and friends. Thank you for listening to my sisters and for listening to my daughter when she comes in, and thank you for the opportunity to speak to you. I stand before you today convicted by a jury of a heinous crime, conspiracy to commit murder. I understand that you will be sentencing me today based on their decision, but I do want you to know that I have never and would never want anyone to be murdered, not even the people that want this for me. What I am guilty of, however, is great moral failure at a time in my life where I chose to make reckless decisions that affected everyone around me, and for that I'm truly sorry. These years away from my family and friends have shown me many things about myself that have been hard for me to face. I've spent most of my life caring for myself and my loved ones, but wondering why I never seem to have real joy or lasting happiness. I had been taught to put others first, and I had been taught to give to others. But I realize now that I only gave out of my excess, and I only served others when it was convenient for me. I did love my friends. I do love my friends and my family. But I believe that other people had the same opportunities and support that I did, and that if they did not, that somehow it was their fault. These years away have opened my eyes to the truth of my selfishness and pride that I did live in most of my life. Thankfully, though, it's opened my eyes to the needs of those around me. It has been both heartbreaking and humbling to hear stories from each precious lady that I have met in prison and that I've had the privilege of spending time with, listening to their stories of trauma and pain, which began mostly in their early childhood. These ladies were given no opportunities growing up for a successful future. They had no one to truly love them, no one to care for them, no one to guide them to be successful adults. There was even a lady, when I came back from prison last night, they asked her if she had anybody to call, and she said no. Being able to serve these ladies in prison with the skills and abilities that God has given me has been joy beyond words. I've had the honor of starting up a GED prep class to educate as many ladies as possible to help them reach their goal of just a high school diploma. I've been able to serve my dorm daily by managing and directing the IBLP curriculum in the JOY program. I've also had the great opportunity to develop training materials for an upcoming stewardship training seminar that we're doing, leading all the ladies in. I'm extremely thankful for these opportunities to see the needs and to serve in these capacities. However, I am well aware that no amount of good deeds can bring my husband Mike back, and no amount of service to others can stop the pain for everybody who knew him. There's nothing I could do to bring Mike back to his grieving mom and to his brother. There's nothing I could do to give my daughter her father back. If I could trade my life for his, I would. Mike was a loving husband and father. He loved his parents. His dad was his hero. He loved his mom. He loved his brother. He loved his friends. He loved his job. His boss and that family, they were family to him too. He had more people that loved him and that still do more than anybody that I've ever known. And everybody who knew him knew that he loved his little girl more than anything in the world. For both of them, I'm striving every day to turn this nightmare into something good. These years in prison have allowed me to find my purpose, which is serving incarcerated women and doing everything I can to help them not return to prison. I strive to honor Mike and our daughter every day by meeting the needs of the women I live with, by sharing with them my story, my failures and my bad choices in hopes that they will make better decisions to go on and live successful lives and to be productive members of society. Today, Your Honor, I humbly request a sentence of 21 months. I also make a commitment today to you, Your Honor, to my family and to myself, that I will honor Mike's memory by fulfilling my purpose to serve incarcerated women to the best of my ability each day of the rest of my life, both inside and outside of prison. And I thank you very much for this time and for your consideration.
Thank you, Ms. Williams. Mr. White?
Oh, no, I'm sorry, Your Honor.
Oh,
Your Honor, I have a brief argument, but I think if Denise's daughter is ready, maybe it would make more sense to have her come and give her statement first.
all right. Very good. Mr. Harrison?
You may have pleased the court, Your Honor. Ms. Ansley Williams is here and would like to make a brief statement on her mother's behalf.
Yes, sir.
Thank you, Judge Carroll, for allowing me to speak with you today. I know my mother and got to know Brian Winchester, the man who killed my father. I came to understand the relationship between my mom and Brian. There are two key things I ask Your Honor to consider about their relationship from my personal experience. First, there is simply no way my mother would conspire with Brian to kill my father because my mother would not choose to purposely cause me pain to endure the emotional pain of his passing. She could not bring herself to do that, as she did the opposite by keeping his memory alive on a daily basis. She always wanted me to meet a man with the same ideals that he had. He loved me and my mom more than anything, and every day I still felt his love in my house through my mom. My mom made sure he was never forgotten and always made me feel his love. She has shown all during my life how much she cares for me and would do nothing to hurt me, even being my most supportive person these past almost 4 years. Second, as I got to know Brian and saw his actions daily as he was a figure of authority in my household for many years. It is not that he so much dominated my mother, which he did, but he acted independently of her. I never once saw him consult with her about anything. He did not ask for her advice or opinions, rather forced his opinions on her. He acted on his own. He was erratic in his actions, which was most evident when he kidnapped her at gunpoint only because she wanted a divorce. Growing up, I saw he was impulsive, spur of the moment, and did not care what she had to say, or for that matter, what she felt. I could add much more, but I believe the things I've stated to you as clearly and precisely as I can. I am deeply concerned about the physical and emotional toll that this is taking on her. Would you please consider the lowest sentence of 21 months so she can come home and we can begin to heal together from the pain he caused us? Thank you.
Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Harrison.
Thank you.
That concludes the testimonial part of it, Your Honor. If I could make a brief argument about the sentencing at this time, I would like to do.
Do you want to do that now, or do you want to do it at the conclusion of the state's case?
You know, that's fine. If you wanted it, in other words, you're suggesting just let the state present their testimony and then we can do. Oh, yeah, that's fine. That's fine.
And you may have anything you want to add after the state's.
I think that's fine. Thank you.
Very good. Mr. Fuchs?
Thank you, Your Honor. No, I put that picture up now because I want to remind why we're here. We are here because Mike Williams is dead. And we are here because Mike Williams is dead because of what Miss Denise Williams has been convicted of doing, and that is a conspiracy to commit murder that ended in his death. That's why we're here. We are here because Miss Cheryl lost her son We're here because his brother lost a brother. And during this process, we're here because Ainsley lost a father, and she also lost Mike Williams' entire side of the family because of the actions of Denise Williams. Your Honor, Ms. Cheryl Williams would like to talk to the court, please.
All right.
Let me give this one to
You
She won't reach. Is it caught? No, not good.
Right here? Right here? That's probably better. That's probably better.
Judge Carroll, my name is Cheryl Ann Williams. I am the mother of Jerry Mike Williams, the young man who was murdered on December 16th, 2000. Judge Carroll, I am here today to ask you to deny Denise Williams' request to reduce her prison time for the charge of conspiracy to commit murder. Nick, Mike's brother, and I last saw Mike on Thursday night, December 14th. He and Denise told us that they were ready to have their second child. Mike was very happy. He wanted his daughter, Ainsley, 18 months old, to have a brother or sister. Mike also told us that he and Denise were going to Apalachicola to celebrate their upcoming 6th wedding anniversary. They would leave on Saturday as soon as he and Brian Winchester got back from duck hunting at noon. I talked to Mike on Friday. He told me he was going to play Santa Claus and ring the bell for the Salvation Army as part of his Rotary Club duties. Then he, Denise, Brian and Kathy, Ainsley and Stafford were going to the Christmas pageant in Thomasville. He would call me when he got back from hunting on Saturday. Judge Carroll, I never got that call. Instead, Denise called Nick at 3:00 p.m. to tell him that Mike was missing. He didn't come home from hunting. Her father and a friend had driven to Lake Seminole and found Mike's truck and boat trailer. There was no sign of Mike or his boat. Denise told Nick that Mike had gone hunting by himself because Brian had called at 3:00 a.m. to cancel. Judge Carroll, what none of us knew at the time was that Denise and Brian had been having an affair for years. For months, she and Brian had been planning to murder Mike. They were going to make it look like an accident. Even though Denise didn't love Mike, she didn't want a divorce. A divorce would have ruined her social reputation. She didn't want Ainsley to be old enough to remember Mike, and she wanted to collect a $500,000 life insurance policy before it lapsed. Judge Carroll, Mike loved Denise. She allowed him to go hunting on their anniversary, knowing that her lover was going to kill him. All of her problems were solved. December 16th, 2000, my life as I knew it changed forever. There is no How to Find Your Missing Child manual available to help mothers in their search for lost children. I did what God told me to do. I wanted publicity. Denise did not. I wanted a criminal investigation. Denise did not. I begged Fish and Game to get the local law enforcement to do a criminal investigation. They told me Mike had fallen out of his boat and drowned and had been eaten by alligators. I knew this wasn't true because alligators hibernate in cold water. They don't eat. Mike's body was never found in Lake Seminole. Denise had Mike declared dead 6 months after he disappeared. She collected almost $2 million in life insurance money. I worked in my home daycare from 5:00 a.m. to 6:00 p.m. Then I would go out and put up missing person signs with Mike's picture on them. I made a big poster sign and walked the streets of Leon County asking everyone to help me find Mike. I wrote thousands of letters to the media and politicians begging them to help me find my son. I put ads in the Tallahassee Democrat, and I put up billboards trying to find Mike. Judge Carroll, I stood in front of the churches where Brian, Denise, and their families attended. I was holding my big poster on the public sidewalk in front of the churches. The ministers and other members of the churches would cuss me out and tell me to leave. I did not leave. I was told by law enforcement officers that I was crazy. According to them, Mike was eaten by alligators. I didn't do things the right way. I wrote too many letters. I talked too much. They told me to go home and shut up. I did not. After 9 months after Mike's disappearance, he was included in a Tallahassee Democrat article about locally missing persons. When Denise read it, she was furious. She called me and Nick to her house. She told us that she never wanted to see Mike's picture again. She never wanted to hear his name again. She had to get on with her life. She told me that if I continued to try and get a criminal investigation, that I would lose Ansley, my granddaughter, Mike's only child. Judge Carroll, I am a fighter, not a victim. When Denise threatened to take Ansley, I knew it was because she was hiding something. I knew that she knew where Mike was or what happened to him. I love Ansley, but Mike was my son. If I had not done what I did for 17 years, no one would have questioned the alligator theory. It took me 3.5 years to get a criminal investigation. When Denise found out about it, she went through with her threat and took Ansley away from me and Nick. Judge Carroll, my granddaughter was raised by 2 murderers while being denied the love and support of her father's family. She does not know her aunts, her uncles, cousins, or me, her grandmama. Denise told her that we were bad people and that I was crazy. We haven't seen her in 17 years. Denise not only killed my son, she stole my granddaughter. Ansley believes her mother is innocent. For 20 years, Denise, Brian, and the Merrill family manipulated my granddaughter's mind. This is evident in Ansley's support of Denise. She was totally brainwashed. Ansley is a bright, beautiful young woman who was sadly told her whole life that her grandmama Cheryl was crazy and would hurt her. But I am the only one who has never hurt her. I not only sought justice for her father, but justice for her. I pray one day she will be out from under the generational curse her mother bestowed on her. When Ansley is ready, the truth is waiting on her. It is compiled in testimonies and countless evidence that Denise is not capable of loving anyone but herself. She has proved this time and time again. When I found out on December 20th, 2017, that Mike's body had been found and that he had been murdered, part of me died too. For 17 years, I had hoped that my son was alive and would eventually come home. Now, that hope was dead too. The coroner sent me a message. Miss Williams, don't worry, Mike didn't suffer when he died. I disagree. What about the time he's trying to get out of his waders in the freezing waters of Lake Seminole? What about the time he's clinging to a stump in the dark, knowing his best friend whom he loved is going to kill him? Mike suffered horribly. For the rest of my life, when I try to go to sleep, I will see my son clinging to a stump, freezing, wondering why his friend is trying to kill him. I hear him screaming for help. I wasn't there to help him. It will haunt me forever. Judge Carroll, please don't reduce Denise's prison time even by 1 day. Please don't show her any mercy. She didn't show my son any mercy. She took him away from his daughter, his family, and his friends. For 17 years, Denise traveled the world spending Mike's insurance money while his dead body was crammed into a muddy hole on the lake car. When his body was found, he was still wearing his wedding ring. Denise took Ansley's father away from her, and she took him away from his family. Then she took Ansley away from me and Nick. Judge Carroll, if you will make Denise serve every minute of her 30-year prison sentence for conspiracy to commit murder, then and only then will I believe justice has been served for my son, Mike Williams. Thank you.
You don't want to address court, do you? Your Honor, we've heard from people in support of Ms. Williams, and I understand that. But keep in mind, and you go back to the testimony that came out during the course of the trial, Brian Winchester discussed how she had an alter ego. She went by the name Meridian. There was even evidence about the necklace that was bought with the Meridian name on it. Your Honor, there's a book called The New Land. In it, there's a quote, "I see no evil because love is blind." I have no doubts that these people saw what it is that Denise Williams wanted them to see. But these people clearly never met Meridian. We heard that she was a devoted mother, except for the fact it completely ignores the evidence that was presented during the course of the trial regarding the conspiracy to commit murder of Ainsley's father. It ignores the threats that came out from Meridian, that if Ms. Sherrill continued to seek media attention and justice for Mike, that she'd never see her daughter again. It ignores the fact that over that entire time period, Ms. Sherrill has not seen her granddaughter. Meridian stood up here, or Denise Williams stood up here and said, wrote down, "Nothing I can do can give his daughter back her father." What about the grandma? What about the aunt? What about the uncle? Miss Sherrill, Nick, and the Williams family faced ridicule all these years by the friends and family members of Denise Williams about how crazy she was to believe that Mike had been killed. She was right. For 17 years, she was correct while she took the ridicule. Yet Sherrill is going to stand here and say, I can't do anything to give back her father. What has she done to try and give back the grandmother on the side of Denise's family? Mike's family. You know, I watched her up here. There's a term called crocodile tears. I think in this situation, alligator tears may be more appropriate wording. They turned on, they turned off during her statement. Your Honor, this is a lady that stood up here and was able to cry at the appropriate times when she addressed Your Honor. We had a bond hearing in here, and I know Your Honor has reviewed all these things. We had a bond hearing here in the courtroom right after she had been arrested. In that bond hearing, the state elected to play the statement of Brian Winchester. If you were to believe And if everybody else is to believe that she knew nothing about what transpired on Lake Seminole or Car Lake, that would have been the very first time she ever heard what happened to Mike, her beloved husband. We played it. Brian Winchester discussed ad nauseum what went into that particular evening or the morning that ended in Mike's death. He went into the fact that he was there at the boat and tried to knock Mike over and have him drown his waders, which didn't work. And then ultimately shot him in the face. And that would have been the first time she ever heard it. Where were the tears then? Where was the reaction then? This is the first time you've heard how your beloved husband was murdered? No reaction? Yet when she's before a court, she's able to have him. I see no evil because love is blind. Your Honor, the jury of her peers is not. The jury of the peers went through and listened to the case, the evidence, and made the determination that they did. And what they saw was Meridian. They saw the photos of Meridian having a threesome with Brian Winchester, her co-conspirator, and his wife before Mike's death. Those are in evidence. Those are photographic evidence of her being a cheating wife. Mike was worried about her cheating before his death. He was debating about leaving her and taking Ainsley. There was $3,000 missing one weekend from their account that Denise's excuse was she was buying weed. You know, I've been doing this a long time. $3,000 worth of weed is a lot of weed, especially back then, 20 years ago. Yet this is the person of good character that we've heard from? Or is it simply that love is blind? Good character aren't people that take granddaughters away from grandmothers. Good people aren't the ones cheating on their beloved spouse. Good people certainly aren't people that conspire in the murder of their beloved husband. Good people aren't ones that file for an insurance claim 16 days after Mike Williams went missing, while literally all of his friends and family are still on the lake looking for him. It wasn't an emergency funding situation. She was a CPA. They had plenty of money in the account. What they saw was Denise Williams. They never saw Meridian. Meridian is responsible and before you in court today for sentencing. There are arguments in the pre-sentence investigation, in the sentencing memorandum put forth by the defense. I'd like to go into some of those things. They asked for the sentencing mitigator that Meridian was a minor participant in this. Absolutely not. No question the DCA has stated there's a legally she had a minor role in the actual murder. But they did state that her role was sufficient as it relates to the conspiracy to commit murder. Most importantly, the jurors of her peers that heard all of the evidence didn't think her role was minor. And they returned a verdict appropriately. Now, the DCA said that she played only a minor role, and certainly that is going to be the argument of defense counsel. Your Honor, the testimony during the course of the trial, Brian Winchester, that they had talked about this plan on how it is that they were going to commit this murder for over a year. There were multiple different ways they were going to do it. Were they going to do a boating accident offshore where both Kathy and Mike went missing and miraculously Denise and Brian Winchester survived? They even talked about the night before how they were going to set up their alibis with Denise's help. Meridian suggested to Brian that he give her a certain medicine that Kathy takes. Kathy, of course, was Brian Winchester's wife at the time. Because when you combine that with alcohol, it knocks her out cold. And the alibi was to be that Brian was home asleep during the time of this and woke up and went hunting with his father-in-law. So she's actively participating in the drugs to give Kathy to make sure she's sedated sufficiently to set up the alibi. Brian Winchester talked about the roles in the alibis and how they were going to establish the alibis, that Denise was going to stay at home and call her sisters after a certain amount of time to show that she was in fact at home this entire time and didn't have any play in it. She talks about the anniversary. Your Honor, this hunting trip happened on their anniversary. I understand Mike Williams is an avid duck hunter. And I know duck hunters are duck hunters and they go when it's duck hunting season. But there is not a person in this world that can do anything on their anniversary without getting permission from their spouse and significant other. Doesn't happen. That conversation in every household across America is, okay, well, what time are you going to be back? Because we've got to go back on this trip later on this evening because they were going to Appalachia. Who are you going hunting with? Yet when law enforcement goes missing, Meridian never tells law enforcement, oh, by the way, he went hunting with Brian Winchester. Most importantly, Brian Winchester said her role was to make sure that Mike went hunting on that day. I can't stress this enough. If Mike doesn't go hunting with Denise's permission, he is not dead. For him to be dead on that day, he has to be shot by Brian Winchester, but most importantly, he has to be there. Brian Winchester can't shoot him, he's not there. That is not a minor participation. That is an active participation in the conspiracy that ultimately led to his death. Argument was in there that Brian had to encourage her after she had cold feet. It's debatable whether that's really the way it was stated. They had a conversation afterwards that reinstated it for the following year. But she's here because of what she conspired to do before that date. The sentencing we're talking about is conspiracy that was prior to that date and, of course, afterwards as well. There's an argument repeatedly in appeals and everything regarding disparity in the cases and the sentencing. Apparently that's only good when it fits their suit, when it fits their argument. Because now they're sitting there arguing for her to be let loose at 22 months prison. How is that even remotely comparative as to the sentences that have been imposed? Brian Winchester is serving 20 years in the Department of Corrections, followed by 10 years probation. The argument is Brian got less. Your Honor, there actually is a statutory mitigating circumstance regarding him. He cooperated with state to resolve a current offense and other offenses that were, quite frankly, unsolvable. Meridian had the same opportunity for 17 years to do so. She talks about the duress and the fact of the incident that happened up in Atlanta. Yet somehow that didn't trigger her to say, hey, maybe this is the guy, if she doesn't believe that Brian Winchester is the guy that committed this murder like she so claimed for so long. Never said, oh, this guy came at us with a gun. Maybe he did do something, like the rumors have been circulating around this community for all those 17 years that she never ran from. What about when he put a gun to her head and kidnapped her on that day? She was brought there and given the opportunity to talk to and asked repeatedly about this situation. Her brother-in-law was there saying, how can you possibly say he didn't do this when he just did and held a gun to your head with all the situations? Get her answer? I don't want to talk about that right now. Is that because she didn't know he didn't do it and she didn't have a role? Or is it because that is the pact that her and Brian Winchester had? That no matter what happened, they would never tell the roles of the other person. Is that why she was so surprised when she found out that Marcus Winchester knew of the murder? When she was flat out accused of being a murderer herself by her friend? We heard from her friend that said that she was not the same person after Mike was killed, went missing. She was withdrawn and quiet. Is it because she missed Mike? Or is it because she knew what she had done resulted in his death and murder? There is no evil because love is blind. Or do we look at the facts? And we look at the facts of the insurance policy immediately afterwards. Do we look at the cheating on him beforehand? Do we look at the fact that Brian Winchester, or Mike Williams, was ready to leave her after she'd taken $3,000 from her account? Do we look at the fact that she took the daughter away from her grandmother under threat to make sure there wasn't a situation or a investigation? Do we look at the facts that clearly showed Meridian was in fact involved in the conspiracy to commit this murder, and leave aside what Denise Williams wanted everybody to see? As I said, they had a pact they wouldn't tell. When she is accused of murder, her only concern is that Marcus Winchester knew about it.
Brian told me that y'all planned it.
And what? Oh my God.
And Marcus showed up at the shop later that afternoon, you know, telling me how I would have to take this to my grave, that it would ruin Marcus' life, it would ruin, you know, apparently Brian told Marcus that he had talked to me, and he went on to just tell me, Marcus went on to tell me how my life would be ruined, how I would never be able to start over, if Stefan's life was ruined, if...
So Marcus knew?
Hey Denise, I've been a friend of yours for 20 years. I know you just committed murder. You're involved in the murder of your husband, Mike Williams. Wait, Marcus knew? That's your concern? Is that the mark of a good character and all the things we've heard about? Or is that Meridian? Worried about the pact that was kept between her and Brian Winchester. And as far as that pact goes,
Well, I mean, I know that you know something, Denise, because whenever I was going out to see Marcus, you're like, tell Marcus to tell Brian I'm not talking.
Yeah.
And I knew what that meant.
Tell Marcus to tell Brian that I'm not talking. Your Honor, if she's not involved in the conspiracy, and she's not involved in everything else like that, they're claiming she wasn't, what is the purpose of that conversation? Or is that conversation consistent, again, with what we know Meridian and what the jury's determined Meridian had done?
Sir, part of the plan was that I wanted Kathy to basically be as drunk as possible the night before because I wanted her to sleep late, eat late the next morning. My alibi, the plan was that all of this would occur very early in the morning, and I would have time enough to get back and meet my father-in-law up near I-10 and Thomasville Road to actually go on a hunting trip with him. So that was going to be my cover, going to be my alibi. Her alibi was going to be that she was at home with Ansley. And the plan was when Mike didn't come back home that eventually she was going to start calling her sisters and her dad from her house phone so that she could establish that she was at the house, prove that she was at the house with Ansley.
All right. So what was the plan to make this happen? What happened?
So Kathy and I went out and went to the concert, got home late. She did have a lot to drink. There was discussion between me and Denise, and I can't remember if I actually did this or not, or if I did it the week prior, or I just really can't remember, but I remember Denise and I talking about there was some medication. There was some medication that Kathy had. And we talked about giving her a little bit of that medication that would cause her to sleep really heavy and make sure that she slept really good through all of it because I didn't want her to wake up and realize how early, I didn't want her to know how early I was leaving the next morning. So the plan with Mike was that I would meet him at a gas station on Thomasville Road up near the overpass. Well, the overpass I don't think was there at that point, but meet him up at a gas station up near the McDonald's up there. And I met him there. I had told him that we were going to go to a secret special spot to go hunting. And that he needed to bring his waders. I had to make sure he brought his waders because the belief was there was kind of like there still is probably like a duck hunter's myth that if you fall overboard with your waders, you're going to sink really quick and drown. So I had to make sure that he brought the waders. And so I told him about this, great spot that we were going to go, and he needed to bring his waders. So I met him at the gas station, and I told him when he drove up, I was real paranoid about phones and him calling me and there being a record of him calling me. So I told him that my battery was dead on my phone, that there was no reason for him to call me as we were driving over to the lake, because normally we would have called and talked to each other on the phone or even ridden together. I don't even remember how or why I told him that I needed to use my vehicle instead of just going in his, but somehow I came up with some reason to do that.
He says call him and try to get him to make sure he was going to get the waiters. When did you call? Talk about that?
I don't remember specifically. We talked several times. Mike and I talked every day ourselves. So, we talked about hunting all the time. And we talked about this trip several times prior to it happening. So I followed him over to the lake. He had his boat behind his Bronco, I followed him in my white Suburban, Lake Seminole, which is about 50 minutes away. And I told him what landing we needed to go to. And so we pulled into the landing and launched the boat. And I said something. I had to make sure that he had the waders on, so I said something about we're running low on time, or we're going to be really pushed. And
why is it so important for the waders to be on?
Because I believe, and we believe, that if you fell overboard with the waders on, that you would sink pretty quickly. So I told him something like, we're running late, we need to go ahead and put our waders on, here and now, before we get in and go. And so we both did that. And because I knew where we were going hunting, I was in the back of the boat driving, and he was in the front.
What kind of boat are we talking about? Like an airboat, or what are we talking about?
It was what's called a canoe. It's basically a canoe that has a flat back that you can put a small motor on the back of it.
I'm familiar with canoes. Canoes can be a little tipsy.
This boat was, yes, basically like canoes, so pretty tippy.
Okay. So you had to put a little water in your head now. You're driving.
Yes, sir. I was driving, and I know I was very concerned about the time. Everything had taken longer than what I had anticipated, and I had to be back in town early enough in time to meet my father-in-law for my alibi trip to occur. And so we headed out, and there was a deep area, maybe a couple hundred yards from the landing that we put in at. And we got to that area that I knew was a deep area, and I don't remember exactly how I got him to stand up, but I don't know if I pretended something was wrong with the motor or the weight in the boat was off or something, but I basically stopped the boat and got him to stand up, and when he did, I pushed him into the water.
What happened next?
So he was in the water, and he was like struggling, and the motor of the boat was still running, and I pulled off just a little bit to get kind of away from him so that he couldn't reach back into the boat. And I didn't know it at the time. I didn't know if he was trying to swim, or I didn't know what was going on, but what I came to find out, or eventually realized, was he was taking the waders and the jacket off. And he got those off, and I think I forgot to tell you about this part before, but I remember now that area of the lake had a lot of snags, a lot of dead trees that come up out of the water, and there's a lot of stumps that come up out of the water. And he swam over one of those stumps and held on to it. And he was panicking, and I was panicking, and none of this was like going well I thought it was going to go. And I didn't know what to do, but he started to yell. And I didn't know how to get out of that situation. And so I had my gun and boat. And so I loaded my gun, and I made 1 or 2 circles around, and I ended up circling closer towards him, and he was in the water. And as I passed by, I shot him. In the head.
Your Honor, we are here because of the role that lady, Denise Williams, conspired with that man to kill Mike Williams, that ended up in his death as it was just described. That ended up in his death, as Ms. Sherrill said, with Mike clinging to a stump and begging for mercy. The argument is going to be made that this is Brian Winchester. This is Brian Winchester. This is Brian Winchester. Except Brian Winchester's testimony, as the juries heard it, and jury made a determination, was supported by stubs to concerts. It was supported by photographic evidence. It was supported by receipts for Meridian's necklace. It was supported by love letters from Denise Williams to Brian Winchester. It's not just Brian Winchester's testimony. He explained everything, but it's supported by everything else. The argument's been made regarding the betrayal of a friend that ended up in the shooting. Proportionate sentencing. Which is the bigger betrayal? The friend or the wife and friend of marriage? I would certainly argue that the betrayal of his wife and his friend and the mother of his child is far greater than the betrayal even of the person that actually shot him. Because she's the one. If she doesn't cheat on Mike with Brian Winchester, we don't go down this road. If she doesn't give permission on their anniversary for him to go hunting, we're not here. She's the one that set all of this in motion. That's what the evidence has shown. And she's the reason that he laid underneath Car Lake with his wedding ring on, deteriorating, and was ultimately found, and justice was served by the verdict of the jurors almost on the exact anniversary of his death, 18 years later. And Your Honor, we are asking you that you continue to have justice served by sentencing Ms. Williams, Meridian, to 30 years in the Department of Corrections. Thank you.
Mr. Pavlov.
Thank you, Your Honor. Most of what you heard from the prosecution here is a rehash of the case. A little bit of the bond hearing testimony from hearsay testimony at the bond hearing from Brian Winchester, little snippets of the most favorable direct examination during trial. There's a lot of it that I can take issue with. Just as an example, the love letter he's talking about was written 4 years after Mike disappeared. It doesn't show that they were having an affair at the time, but there's a lot of putting little bits and pieces together like that. And my question, though, is why are we retrying the case here? The jury found Ms. Williams guilty of conspiracy. That is a fact that I have to deal with. That is a fact that you have to deal with. And just to dredge up all of the things that happened at trial doesn't really answer the question. Now, Mr. Fuchs did talk about sentencing. As best I can tell, his sentencing theory is that this crime was actually committed by somebody else, somebody named Meridian. He said that over and over again. And I'm sitting there thinking, why is he saying that? And then it dawned on me. He has to make her out to be some monster that she isn't in order to get the sentence that he wants. He knows that if you look at her record, if you see her for what she is, if you see her family for what she is, the sentence he's asking for isn't even remotely justifiable. And so he pretends that this isn't Denise Williams, this is some fictional character named Meridian. Judge, we've had enough of that. This case has been infected with all kinds of misinformation and disinformation in social media. And I'm just asking you to get beyond the fantasy here and see Miss Williams for who she is and what she is. Now, I want to make a few comments in mitigation here, but first I want to put this case in a broader context. Denise Williams was convicted of conspiracy to commit murder on the testimony of Brian Winchester, the man who committed the murder. The state gave Brian immunity for his testimony against Denise. He agreed to give that testimony while he was in custody facing a life sentence for kidnapping Denise at gunpoint. He has never served a day in prison for murdering Mike Williams. He has never served a day in prison for the conspiracy to murder Mike Williams. And now Denise Williams is the only person here who can answer for the crime, the only person who can possibly satisfy Cheryl Williams's grief. That's not fair. I think the way this case was handled, in fact, the way it even came to be a case in the first place, should be very troubling. It is very troubling to me. It doesn't change the fact that you have to sentence her. I know that. I understand that. But I think that these basic facts about how this case came to be and the relationship of these parties has a bearing on the sentence, the just sentence that you should impose. Now, as you know, the lowest permissible sentence under these sentencing guidelines or the criminal punishment code is 21 months. In our sentencing memorandum, we outlined 4 mitigating factors. I'm not going to go over them in detail here because I know you've read that, but I do want to make a brief comment about each one of those to add a few points about the mitigators. The first one, and I think the most important one because it's a statutory mitigator, is that she had a relatively minor role. All those people out there in the land of Facebook and Twitter who think she masterminded this, that is simply no evidence of that. None. We have to go by the facts. This is a court of law, and we have to look at the facts. And the facts were outlined by the First District Court of Appeal in their opinion. They started out their opinion by saying that, you know, it takes very little to convict somebody of conspiracy. And I think you know that from your own experience. It doesn't take a whole lot. And then they went on to say, in fact, she actually she had very little involvement, as a matter of fact. Here are some direct quotes from the court's opinion. This is the court speaking. This is not me as an advocate. This is the court. Brian never testified about anything Denise did or said to incite or encourage him to commit the murder. He planned a lot of it. He instigated a lot of it. Certainly, there was no evidence that Denise concocted the plan or enlisted Brian to murder Mike. I would ask you just to think about how those objective comments by a court reviewing this evidence line up with what Mr. Fuchs just said. And then the final thing the court said, notably Denise at one point was getting cold feet about the idea, and Brian had to encourage her to be on board before he would move forward with the plan. So you get the clear picture from the court opinion that she was a relatively minor participant in Brian Winchester's plan to kill Mike Williams. And now I think I think the important thing about this is that it's a statutory mitigator. It's not just a lawyer coming up here with some excuse, oh, he had a hard childhood, he wet the bed when he was a kid or something. This is serious. This is what the legislature the Florida legislature says is a statutory mitigating circumstance, one that a court could consider to go below the lowest permissible sentence. Now, I know you can't do that. She's already served twice that much time. But I make the point only to say that it's a very important mitigator, one that's recognized by the legislature. Now, one more comment about her involvement. I think one of the most telling facts about her involvement, or the degree of her involvement, is that Brian Winchester testified that he never told Denise that he shot Mike Williams. He never told her. To this day, Your Honor, Brian Winchester has never told her that. So the question I have, how involved could she have been if he went out and did this and didn't even bother to tell her? You know, it makes me wonder whether she was involved at all. And I know you and I are beyond that point right now, but I think it's something that we have to think about. There are some non-statutory mitigators too, and I've been careful to point out in my sentencing memorandum that these are all non-statutory mitigators that have been recognized in the case law. And the first of these is that the defendant has been an exemplary inmate. I don't think there's any question about that. You know from the letter that you got from Ruthie Westfall from the Department of Corrections, you've got people inside the Department of Corrections saying, this is not Meridian. This is Denise Williams, a person who's done all these good things in prison. She started this. She had been very involved in this Joy program, which Ms. Westfall outlined. She literally started a GED program in the women's prison, was taught 20 other women on the way to their GED, and I'm informed that one of them actually did get a GED. She teaches other inmates how to play the piano. So, you know, Judge, this is not Meridian. This is Denise Williams, a good person. And I think the thing that is the most telling thing about her activities in the prison is that she did all of this when she was facing a sentence of life without parole. Down at the DOC, they call those ladies toe taggers. The only way they're getting out is in a box with a tag on the toe. That's what she thought she was when she did all of this. Now, what does that say about her character? It says that she's going to try to do good things, try to make the best of her life, no matter what her circumstance is. Now, another mitigating factor is that, and it's been recognized in the case law, is that the court does have the opportunity to try to even out the disparity in the punishment. Let me correct something right now about this. Brian Winchester got 20 years. He didn't get a day for this murder. He got 20 years for kidnapping Denise Williams at gunpoint. So that doesn't factor into this at all. The disparity I'm talking about is the fact that the state now seeks to punish Denise for her minimal role in a conspiracy when they've effectively pardoned the guy who committed the crime. I hope that I'm not the only person in this room who thinks that's unfair. Now, I know you can't iron this disparity out. It's impossible, but it's only impossible because the state decided to handle the case this way. But I think at the very least you can consider that as a point of leniency, and our case law says it is a legitimate point for you to consider. Now you have you have two others that I'll talk about collectively, that she's a good parent. You know that from the previous letter that her daughter wrote to Judge Hankinson before the first sentencing, went on to explain all of the virtues that Denise instilled in her, and what a good person she thought she was. And then you have numerous character letters, and you have had character testimony here today tell you, and you know, I don't think all these people who came up here and testified or who wrote letters are naive people who think that Denise is actually somebody other than who she is. I'll let you decide that. I mean, I don't think that's a reasonable argument. Let me say that I think you should be especially careful in considering the testimony of Denise's daughter. She is also Mike Williams' daughter. And that makes her, by law, the closest relative of the victim. Now, the citizens of Florida, when they adopted Marcy's law in our Constitution, made it clear that they want the prosecution and the court system to pay careful attention to the rights and the obligation, the rights and the wishes of victims. And let me just say, she has been completely ignored through this whole proceeding. I don't know if the victim advocate ever talked to her. But my point here is that her opinion is as important, if not more important, than any other victim. It's not less important just because it doesn't line up with the state's narrative about the case. Marcy's law doesn't say you pay attention to the victim only when the state agrees with the victim. So I ask you to give careful consideration to that. Now let me say one other thing about this before I close this presentation here. I understand, I'm reluctant to say this, that I understand Cheryl Williams' pain. I can't really say that. I've never been in that situation. But I try to imagine how horrible it would be, and I concede that it is truly horrible. But if she's angry, she should be angry at Brian Winchester, the man who killed her son. If she's angry, she should be angry with the state attorney for deciding to pardon the man who killed her son. Mr. Fuchs gets up here and says, oh, it makes it look like it was practically all Denise's deal. We know that's not correct from reading the court opinion. It's just not correct. And I mean, I don't know. I think this is just very troublesome when you have a situation where now, what are we doing now? We're trying to punish a person who talked to somebody about committing a crime when the person who committed the crime is not serving a day in prison? I mean, I'm sorry, but it just doesn't make any sense to me, Your Honor. Now, let me just close what I have to say about the sentencing guidelines. Oh, let me back up. I did miss one thing I wanted to say. And in reference to the involvement, Mr. Fuchs made a point, he made a point numerous times about how Denise gave Mike permission to go hunting that day, and that therefore she was involved in this murder. Your Honor, there is no evidence in the record anywhere that Denise gave him permission to go hunting that day. This was a point that was argued out ad nauseum in the First District Court of Appeal, and the state couldn't come up with a single line of testimony to support that argument. So it's just not true. Let me just close by saying that I think that there's a point to having these sentencing guidelines. I didn't make them. They were made by the Florida legislature. It's not, you're not just a lawyer here advocating for a client. This is the law. I don't make it up. The score in this case is what the score is. It's 21 months. Now, the state asked for 30 years. Judge, I just have to say, I think that's outrageous. Why would you sentence a first offender to the maximum sentence? If you're going to do that, what kind of a sentence would you reserve for somebody who had a long criminal record? What kind of a sentence would you reserve for some real horrible gang member who was a real nasty person? I mean, it's unthinkable. I really think what they're trying to do is to maybe say, well, okay, well, I'll split the difference and give her 15. And that's going to be way too high, in my opinion. But I just have to say, I think the guidelines are the guidelines. And I would just say this. The minimum sentence of 21 months exists for some person. It exists for some person in the universe. If it doesn't exist for a person like this, Your Honor, then who does it exist for? I mean, you're an experienced trial judge. I know you've seen a lot of people come before you. I would just ask you to make that judgment yourself. Well, of course you will. I mean, magnanimous of me to say that. I don't mean to infringe on that, but I'm just asking you to use your own judgment to say, well, if this minimum sentence that the legislature has told us exists for this person or for a person, if this isn't the person, who is? I thank you for your careful attention to all of this, Your Honor. Thank you.
Your Honor, I do have one comment regarding what Marcy's law and the facts that were represented by Mr. Padovano are absolutely 100% incorrect as it relates to Ainsley. The state attorney's office reached out to her through her counsel and said we were willing to sit down, as well as beforehand we reached out to family members that we were willing to talk to her.
Mr. Padovano.
Well, I was just going to say, I thought your order was that.
No, you get the last word on anything of merit, and he had some a legal thing he wanted to raise, and I'm okay with that.
He did last week agree to speak with Ainsley, only after Mr. Harrison wrote a letter.
Well, again, I'm not all that particularly concerned about that right now.
Yeah.
Is there anything else that you want
to
say?
No, sir, I've said everything I need to say.
Mr. Wade, did you want to say anything?
No, Your Honor. Thank you very much.
Anything else anybody wanted to offer as far as being heard before the court imposes sentence?
No, Your Honor.
All right. Well, I'm going to take a few minutes and go out and recollect my thoughts. Plan on it being about 10 minutes. That'll give me time to outline what I want to do, and we'll come back in. We'll be in recess for a few minutes.
Thank you, Your Honor.
Anything else anybody wanted to say before I proceed?
No, Your Honor.
No, Your Honor.
Well, before I start, I do want to address everybody. I am about to pronounce sentence here, and if anybody on either side feels that they can't comport to courtroom behavior beforehand, I just simply ask that you leave now. I don't know of any judge that looks forward to handling a sentencing, and it, at least for me, never gets easy, and frankly, I hope I never get to the point that it does. I do want to explain what I'm about to do here a little bit. Normally, I try not to say too much on the bench, and I got a picture of Will Rogers here on my bench book saying never miss a good chance to shut up, and I try to follow that. But I think it's important to talk to everybody here today, because I did read all of the letters from family, friends, and on both sides, and I do not doubt the sincerity of a one of them. From the Williams side, they all indicate that Ms. Williams was a good person, a mother, and a solid friend, and that they can't square why we're here with the person that they know. We have had some discussion about what went on, and you can't really do the sentencing without having an appreciation for why we're here. And I have gone through and I read and reviewed the transcripts in the file and the holding of the first district, but the evidentiary portion of this conviction has already been sustained, and the summary of it is pretty straightforward and to the point, and the evidence shows that Denise and Brian had an agreement to kill Mike, and that Denise intended for Brian to kill Mike. The first district in their summary noted that it showed they discussed alternatives methods of killing Mike, and that Denise squashed the plans that she thought were too risky. That after she called off the first planned hunting trip, Brian met with her to see if she still wanted to go through with the murder. He did not want to stage the accident if Denise was wishy-washy. She again agreed that they should proceed. There could be no doubt that at a minimum, the multiple meetings between Brian and Denise to discuss the plans for the murder made it more likely that the murder would actually occur. The court noted this increased likelihood is precisely the public danger that conspiracy statutes seek to mitigate. There was also evidence that Ms. Williams intended for the murder to actually happen when she entered into the agreement with Brian. The evidence was certainly enough to establish that it was her intent to engage in concerted criminal activity to support a conviction for conspiracy, her payment of the extra insurance premium, to extend his life insurance policy, her agreement to come up with an alibi, and her preference for one plan over another, all circumstantially showed her intent to participate in a conspiracy and to see that its objective was accomplished. The court also commented on her actions after his murder, which provided accompanying circumstances from which the jury could infer her involvement in the conspiracy. She tried to use the promise of visitation with her daughter as an incentive to stop Cheryl's campaign to reopen the criminal investigation. And after Brian's arrest, she conveyed a message to Brian's father that she was not talking. I don't find that she was a relatively minor participant in the conspiracy that killed Mike Williams. I would like to comment that there is a problem here in that the state of Florida had to make a deal with the devil to bring Mike Williams' body home, and it was a pragmatic decision that they had to do. And this court is not capable of giving perfect justice here today. Mr. Winchester is not before me. But the truth is that Ms. Williams could have stopped this on December 16th as she had done before. When Mike Williams left the house that morning, Ms. Williams knew three things: that if things went as planned, he wasn't coming back. She wasn't going to have to go to Apalachicola on the anniversary trip, and there was $1.75 million or so in insurance that her co-conspirator had helped her to obtain. This is a sad case. This case is a tragedy. This case is a waste, and it didn't have to happen. Ms. Williams, having been previously found guilty by a jury as to count one, conspiracy, and having already been adjudicated guilty of that count by Judge Hankinson, I now find that it is the judgment of the law in the sentence of this court that you be committed to the Department of Corrections to be in prison for a term of 30 years. This sentence will be with credit for time served to date, and I believe would be nunc pro tunc to the original sentencing date of February 6, 2019. Court costs are there's a $2,100 fine, the $105 surcharge, and the $420 in court costs. You would have 30 days from this date within which to appeal the sentence and judgment of the court, and if you could not afford a lawyer, one would be appointed to represent you on any appeal. Counsel, have I left anything outstanding?
No, Your Honor.
That's it.
All right. Ms. Williams, do you understand the sentence that I've imposed?
Yes.
All right. Thank you, everybody. We'll be in recess.
She's upstairs. Yeah. She's upstairs.